KCL Institute of Laws, Jalandhar. I completed it in 2021.
Alright. We are going to ask you some question out of CRPC.
Sure.
Can you narrate what is the procedure for dealing with criminal complaint of warrant cases?
Sure, sir. Criminal complaint is mentioned in 2 clause D of, firstly, it is mentioned in 2 clause D of CRPC, where it can be filed by any person. So, the criminal complaint is taken by a magistrate, and firstly, magistrate can inquire about the ingredients of the complaint, and while inquiry, he can examine the witnesses produced by the complainant along with it, and then he takes
Under which section he is examining the witnesses?
201 to 204 of CRPC.
20?
I am not recalling it properly.
Exact.
204.
Knowing the exact section that under which the complainants are examined.
So I cannot
Or it's
recall it
not.
properly.
Which is the section? Under section?
So warrant is
Yes.
244.
No.
Yes.
Preliminary evidence. Starting.
200.
Yes.
200.
That is 200.
200, sir.
Section 200.
Yes.
The witnesses are examined in section 200. Then what is the next procedure?
Then the magistrate takes cognizance of the offence, and preliminary evidence is again taken to check if charges are to be framed or not. And then along with it,
Suppose the magistrate has taken the cognizance and he has summoned the accused is before you. You are working as judicial magistrate. Accused is standing. Then what next action will be taken by
charges will be framed against the accused
under this section?
211 of CRPC provides for the charges, and for the complaint cases, charges will be framed.
Whether any evidence is required to be taken or not before bringing the charge?
Yes, sir. Complainant's evidence is to be taken.
Under which section?
So I
No,
cannot.
remember that, President. Go through that.
Sure, sir.
Because they want to know whether you are doing practical working of the court.
Yes, sir.
Therefore, go through all the sections that under this section. For example, when a criminal complaint is filed, it is filed under section 200.
Yes, sir.
Witnesses are examined under section 200.
Sure, sir.
Then the accused is summoned under section 204 if there is a sufficient material. Now thereafter, evidence is recorded. There is a particular sections 244 under which evidence is recorded. Thereafter, charge is framed under section 246. Go through all these sections.
Yes, so I have to brush up quite a bit.
Go through that.
Sure.
Because practically criminal complaint, then police challan. Can you narrate the procedure in police report case?
Yes, sir.
And what is the procedure of warrant case?
The procedure of warrant cases starts after investigation is completed and challan is submitted to the magistrate under 173. The challan is formed and submitted to the magistrate. Then magistrate takes cognizance, and after taking of cognizance, magistrate proceeds to frame charges after calling the accused.
Can he be discharged? Can the accused be discharged at that stage? When the police report is before the judicial magistrate and he has heard the argument in order to see whether we should name the charge or whether we should discharge the accused, whether he can be discharged or
Yes, sir. If it appears to the magistrate that the contents of the police report are not sufficient to prove a form and
can he
apparent,
refer to the sections also?
I believe it's section 227.
Is such which is the section? You are recalling? Yes, sir.
So 229. 29. 228.
No, judicial magistrate is framing the charge. He is discharging the accused. Judicial magistrate.
So 245 in one cases.
No, it is a police report. See that also. Any student who is sitting? Yes. Nothing. You might be knowing.
Sir, discharge section 13, 238 and 245.
239. It is 239.
239 and
It is under section 239 when accused is discharged before framing the charge when the police report is there. Now thereafter, if the magistrate is of the opinion that charge should be framed, then the charge should be framed under section 240. Yes, sir. Your question.
Can you tell us whether a marriage among Muslims is a contract or a sacrament?
According to Mullah, it is more of a contractual nature, but if we go through all the provisions, it is not purely contractual in nature, since we are referring to dower and we are referring to, there are provisions like mutta marriage, and if we cut out the mutta marriage and the other normal marriages in Muslims, we look at that, then we can say it is not purely contractual, since there are other provisions regarding it where divorce is not easily granted. There are grounds which are to be referred for getting divorce.
I disagree with you on that point. Because I think Supreme Court has also discussed this in a few cases and they have held that it is purely contractual. Because first of all, there is a proposal from one side for marriage.
Sure, sir.
And then there is acceptance.
Yes.
And with that acceptance comes consideration.
Sure, sir.
So if you look at it, even with divorce, the husband can even announce a divorce uniquely by himself.
It
Yes.
is purely contractual.
Okay, sir.
Because it has been held in various judgments by Honorable Supreme Court also, by High Courts also. You cannot. Now you have referred mutta marriage. Whether mutta marriage is for permanent marriage or
It is a temporary nature of marriage where parties already initially come into agreement that we will come into marriage for this period of time only. And
if husband dies during that period, whether a wife is entitled to inherit the property of husband during the currency of that mutta marriage.
sir, I'm thinking about it. Please give me some time. No, sir.
Keep your answer readily available with you. Readily available.
Yes, sir.
Is she entitled to maintenance also under section 125?
Yes, sir. She will be entitled to maintenance.
No, keep everything ready. Yes, sir. One question.
What are the conditions for applicability of filing a review under section 114 of CPC, or in other words, an application for review be filed in which circumstances?
Review can be filed to the same court under the circumstances when there is patent mistake in the judgment itself. If the patent mistake on the face of it, the mistake is so blatant that if, let's say, evidence was produced and it was not read by the court. If, for another example, if evidence was not already available during the trial, but with due diligence, it has come to the knowledge of the parties now only, and it is important for the disposal of the case. Then in such circumstances, review can be asked for.
Can you refer to the section related to review in the CPC?
Yes, sir. 114.
Yes, sir.
What is the basic difference between inquiry, investigation, and trial?
Investigation is purely the domain of police officers, and the magistrate has no call in it. Magistrate can only order investigation under 156 clause 3. On the other hand, trial is the domain of a magistrate in the court, which starts only after taking cognizance of the offence. So in trial, we take the evidence, and in investigation, the purpose is solely to collect the evidence. And in trial, we adjudicate upon the evidence. And inquiry is the domain by a magistrate or any other officer appointed by the court for the purpose of knowing the nature of the offence and elaborating the offence only. Inquiry can also be done by a police officer, and that will be a preliminary inquiry only for the purpose of knowing whether it is cognizable case or non-cognizable case. That's
Can it be done by the police officer also?
inquiry. So any person can be empowered.
Generally, inquiry is conducted only conducted by the judicial magistrate.
Sure, sir.
No doubt, in Lalita Kumari's case, Supreme Court particularly referred that what type of inquiry is that? That is before registration of the case. Once case has been registered, then inquiry can be conducted only by the judicial magistrate. Can you refer to the stage that this is the stage when inquiry starts and when trial starts? When inquiry comes to an end and when trial starts.
So
In a police report case.
In a police report case, I should say trial starts after cognizance is taken of the offence. Once cognizance is taken, then summons us, and I would like to change my answer. I was thinking upon it. So trial starts after charges have been framed.
Trial start after framing the charge.
Yes, framing of the charges.
Inquiry means when the police report has been received
Yes.
and the judicial magistrate is going through the police report. It means he is conducting inquiry.
Yes.
Till the framing of the charge.
Yes.
When he framed the charge, then we will say that inquiry has come to an end. No. Now the trial starts. Yes. Yogi.
What is the difference between a condition and a warranty as per sense of good?
Conditions and warranty both are provided as mentioned in the Act. Conditions are which are required, which are essential to the contract, and if conditions are not fulfilled, the contract will be void. I cannot recall it properly, but the warranties are not essential to the contract, fulfillment of the contract. Warranties are something collateral to the contract, and on breach of warranties, you cannot repudiate the contract itself, but you can seek damages and other remedies which you have mentioned in your contract.
Whenever condition is not followed, we cannot say that it is a void contract.
Yes, sir.
Because then the other party is capable to repudiate that.
Yes, yes.
Otherwise, it may accept, it may say that let us consider this condition to be the warranty. It is option of the party. Yes, sir.
Whether a criminal complaint which is dismissed under section 203 of CRPC, whether there is any remedy available in the Act for it
In the Act itself.
or otherwise.
or otherwise. So dismissal of a complaint by an order of the court. So appeal cannot lie, so party has an option to seek for revision. If I imply it from the Act itself, it is not provided as such, but revision can lie. On the other hand, there is no limit to number of complaints which a person can bring to the court. So person can file a complaint again.
But is there any difference between a dismissal in default and a dismissal under section 203?
Dismissal in default refers to when the party who has presented the complaint does not appear himself. And in that case, the party is not allowed to take the benefit of his own mistake. Rule of estoppel will apply. On the other hand, the dismissal on the behalf of court will be the offence is not made out from the complaint, or after inquiry by the court, it comes to the knowledge of court that no offence is made out.
Yes, Harjinder, you might have gone through all the provisions of TPM. Can you narrate how the lease is terminated by the owner of the property, by the lessor?
My TP is quite weak, but I'd like to answer the question. So,
But in high courts, you will not be given.
sure, sir.
Therefore, keep yourself ready. Everything must be ready with you.
The lease can be terminated by payment of the full amount of money.
By payment of
Yes, when the firstly the period of lease is completed.
can you first of all explain what is a lease?
Lease is property is given to the other person for a limited amount of time.
Or rent,
use.
you can say. In other words, you can use that word also.
Yes,
It is a rented property.
yes. In a way, it is a rental.
How it can be terminated?
Can first, if in the contract of lease there was a time period mentioned, if the time period is fulfilled, it will be terminated. On the other hand, if there was any clause mentioned that on payment of full amount of money you can withdraw your property from the.
Suppose there is no contract. The lessee he is residing in the property, and the lessor he wants to get the property evicted. He wants to ask him to vacate the property. Can he terminate the tenancy? Only on the ground that I don't want to keep it.
No, sir. It will be against the rights of the person whom we have granted the lease.
Is there any provision in TPA which says like this?
I beg your pardon, I cannot recall.
The lesser he is having a prerogative under TPA. He can terminate the tenancy at any time
Okay, sir.
if there is no fixed time. Because it is his prerogative, nobody can ask him to keep them. But under Rent Act, what are the provisions under Rent Act in Punjab?
The provisions under Rent Act are firstly that you have to give to the court a reason why you want the property for your own personal use.
Where the reasons have been provided,
So it starts from section 13 onwards.
in of which act?
So Punjab Rent Act, East Punjab Urban Rent Restriction Act 1949.
Yes. Punjab Rent Act is a different act.
Yes, sir.
It is the section 13 is of East Punjab Urban
Rent Restriction.
1949.
49.
So any two grounds, tell us, any two grounds.
So it is for the use of the person himself, own use, and he is not having any other property in same vicinity. Then he can ask the court कि
Very simple is non-payment of rent.
Yes, sir. It
But
is.
he is not paying.
It is the first ground.
Yes, such.
So, how will you define necrophilia? Whether it is an offence under IPC?
Sir, I have not heard the term actually, but I may be knowing it. If you please elaborate what it is.
So
Sanjay
basically,
explains like
necrophilia basically is an act of sexual intercourse with a dead body.
Sure, sir.
So, what do you think? Whether it will be covered under 377 or 376 of IPC?
Sir. So, under 376, we deal with unnatural acts of sexual offences, and if it covers bestiality and other things, the courts should have jurisdiction to try such an offence under 377. But since it is not covered as such in 377, it can be an act of mischief.
act of
Mischief.
mischief.
Yes, sir.
Mischief with whom?
Because the person.
Yes, Sanjay, have you read that section also?
Will somehow be covered under section 279 of IPC, which is dealing with mishandling with dead bodies by going to, like we say, that where corpses are kept.
Yes, sir.
So it will be covered under that section.
Sure, sir.
It is not covered under the ambit of 376 or 377 because there the persons are alive.
Yes, sir.
So it won't be covered under
Why
that
didn't you
section.
go through section 294 also of IPC?
Sure,
So
sir.
94 also with regard to all these things. Yes, you use that.
Under which circumstances a party to a suit may be put in immediate possession of a property which is the subject matter of the suit?
If he has been dispossessed from the property without any bona fide reason, under section 6 of specific relief act, the party can seek immediate possession of the property from which he has been dispossessed
Under
of.
section 6 of
Specific relief act.
our question is a different question. Here firstly the question. Yes,
Can you please
repeat this question?
There is a property which is the subject matter of the suit.
Sure.
Under which circumstance a party, any party to the suit, may be put in immediate possession of the same property?
If that party is not in possession, there is a specific provision that the court, it will say that will be the pendency of the case. Let us give the possession to this person.
I am not aware.
Yes, Yogita, can you refer to that order 39 rule?
So we are talking about temporary injunction.
Order 39 rule.
39 Rule 9,
Immediate.
it's an interlocutory
Sure, sir.
order.
Immediate possession can be. Sanjay, can you refer to the section of contracted tax? Exactly the same situation. Salary.
Section 69.
69, exactly. Section 69, order 39.
What is it?
Both are talking about this thing. That if some party, it has paid the land revenue in order to escape the property from being sold in public auction, then he is entitled to take the possession, even from the owner also.
What are your views on triple talaq?
My views on triple talaq. So triple talaq, what it seems from the judgment of the Honorable Supreme Court, it is an arbitrary provision and it is empowering, not the opposite of empowering women. So where women are subject to destitution, vagrancy, where rights, these arbitrary rights are with the Muslim men, where they can say triple talaq in different pairs, tours, and can get divorced without any ground. So that is in consonance with the contractual nature of marriage under Muslim Act. But on the other hand, the acts in India are to follow the Constitution of India and for the welfare of the class which needs empowerment.
What is the punishment if somebody pronounces triple talaq?
So it is punishable with imprisonment up to 3 years, I guess.
It's 3 years. Punishment is up to 3 years. Can a Muslim still pronounce talaq at present or
So
after that act?
after
The punishment has been provided.
so they can pronounce talaq, but it is punishable.
It is punishable.
Yes, sir.
Every talaq is punishable.
No, sir. The triple talaq is punishable.
Triple talaq is punishable. A Muslim can still pronounce the talaq,
Yes, sir. Sure.
but not triple talaq.
Not triple
We
talaq.
can use the other method. There are other various methods of giving talaq. Yes, sir.
There was a major amendment in Hindu Succession Act in the year 2005.
Yes.
It is having retrospective effect or prospective effect.
So, Honorable Supreme Court has decided that it will neither be treated as retrospective or prospective. It will be dealt as retroactive act, where the females would be granted the right from the date of their birth, even they were born before the date of 9/9/2005. But the right will be given to them. They will inherit the right. They have the right from birth, but the right to seek separation, partition, will invest into them after the 9/9/2005 date.
Yes, sir.
Can you tell us what is the doctrine of caveat emptor? It is given under section 16 of Sale of Goods Act.
So, buyer beware. I'm talking about that. So, it is the responsibility of the buyer to be beware that if there is any patent mistake which he might have discovered by himself, then it is the responsibility of the buyer. But there are some exceptions to it, where the buyer was dependent upon the seller himself. That the seller with his own skill, and he was dealing in that course of business only, and buyer tells the seller that you give me the property by your own, and in that case it will be exempted. On the other hand, if the buyer himself is selecting the property, then he was having a reasonable opportunity to look for whether there was a patent defect or not. Then the buyer himself is there.
Can you refer to the sections also that where it has been provided?
We're talking about section 16 of
16 of
Sale of Goods Act.
yes, sir.
Where civil suit has been dismissed under Order 9, Rule 8 on the ground that plaintiff has not appeared, only the defendant has appeared when the suit was called for hearing, and then what will be the remedy available with such plaintiff?
The plaintiff has remedies available to him. This will be a dismissal by the court, and the plaintiff has a remedy available to him for filing a fresh suit if he comes with a bona fide reason. On the other hand, he can seek to set aside the certain order which was passed by the court.
As it is provided in Order 9, Rule 9, that whenever suit has been dismissed under Order 9, Rule 8, then the plaintiff he shall be precluded from bringing a fresh suit. Only remedy with him is that he can apply for an order for setting aside such dismissal.
I admit my mistake.
All right. Mr. Harjinder, how you will deal with the civil suits related to mortgages or immovable?
The specific procedure is provided under Order 44 of
Is it more or some other document?
Wait, sir. 34.
34.
34.
Or 34. Can you rate what are the types, what are the kinds of mortgages?
So since my DPJ is weak, I will try to
Take time.
usufructory mortgage, simple mortgage, English mortgage, and there are other kinds of mortgage.
Mortgage by conditional sale.
Yes, sir, mortgage by
If
condition.
there is a mortgage by conditional sale and the mortgagee wants to file a civil suit, what type of civil suit will he file?
Sir, I don't know. I plead ignorance of
Have you heard the word foreclosure?
Yes, sir.
What is that suit? He will file that suit for foreclosure.
There are 3 remedies for
Can
foreclosures.
you narrate that what is the suit for foreclosure? What he will demand in that suit?
That I will pay the money, give my property back.
No, mortgagee. Mortgagee is that person who has given loan.
Yes, sir. So,
What type of civil suit he will file? What he will demand from the court?
I can't say.
Now he will file a civil suit demanding that this mortgage should be debarred from redeeming the property in future because he has not paid the amount on the fixed date. Now go through all types of. Have you go through that order 34? Tell us anything about mortgages of immovable property. That how the court passes a decree in that.
Sir, I have not gone through that in detail.
All right. One more question, very simple question out of this. Whether final decree is passed or preliminary decree is also passed. I think you will not be able to give answer on that. Can you give answer? All right. The Yogita will tell.
So there are 3 remedies under Order 34. One is for foreclosure, sale and redemption. The remedy for foreclosure and sale is available to the mortgagee and the remedy for redemption is available to the mortgagor. In every these 3 remedies, first of all the court passes a preliminary decree and following that under which the various conditions are given depending upon the kind of the suit that is filed, that is either for redemption or sale or for foreclosure. And then following that, a final decree is passed.
All right. I'll go through that order. Sure, very important order. Can you say something about order 37? What is order 37?
Summary procedure.
Summary procedure.
So in summary procedure, issues are not to be framed. Sorry, let me start from the beginning. So, special summons are to be.
Nobody is preventing you from starting from the beginning. Feel at home. Give answer according to your knowledge.
Special summons are to be sent where the defendant has to take a leave to defend.
Special summons have been given in which? Where it has been given? It has been given somewhere.
It is not provided in order 5 as such, but it is provided in order 37,
Yes.
rule 9 I guess. So special summons are to be sent where leave to defend is to be given a notice for 10 days. Within 10 days he must seek the leave to defend.
He must file an application for leave to defend. At the first instance, suppose we have sent him suit. That this is the suit which has been filed and he appears. He should file an application for leave to defend.
Yes sir, he is bound by it. If he does not seek leave to defend at the later stage, the decree will not be valid. It can be challenged.
No, but at the first stage, only his appearance is required. That he will appear and he will not move any application. Now it is the function of the plaintiff. What the plaintiff will do? Can you say, I have guided you, I have brought you at some junction. So he has appeared, defendant
The
has.
defendant has appealed.
What the plaintiff will do now? Yes. Again, you will explain. Yes, sir.
So, Order 37, first of all, summons are issued for appearance of the defendant.
Yes.
The defendant is to come and file his address. And he's also to notify the plaintiff that he is appeared in the suit. After that, summons for decree are issued.
Summons for judgment.
Judgment.
This is the thing. Summons for judgment will be produced by the plaintiff. Then we can move that application or leave to defend. Yes, sir. One question.
Can you tell us what section 105 of Evidence Act deals with?
The burden of proof lies on the person who has specific knowledge of the person in whose specific knowledge the thing is. The burden of proof lies on him to prove that particular fact.
So, section 105 deals with exceptions.
General exceptions. General exceptions. If some accused wants to take the plea of general exception, then
Yes.
he must prove.
I was
Burden
talking
will
about
be on-
106.
Burden will be on him to prove. And the court shall presume what? Can you read that? That the court shall presume something under section 105.
So court shall presume firstly innocence of the accused. No, in 105, the court is to presume that no exception, the case of the accused
No
does not
exception
fall
in
in. Yes.
No exception. Yes, sir.
What is a preliminary issue and whether a decree can be passed without taking evidence in preliminary issues?
Sure. The preliminary issues are the issues which are framed on question of law, mostly. Like, for example, if there is a question of jurisdiction of the court, question is whether the suit is barred by section 9 of CPC or not. In similar cases, preliminary issues to be framed to decide whether the further proceedings are to be taken or not. Then court can frame issues for preliminary. Obviously, preliminary issues are issues in itself.
Yes,
Court can take evidence.
Mr. Harjinder, under which order the court can bring the preliminary issue?
Order 14 itself.
Exactly. What the order 14 says? What is the title of the order 14?
Settlement of issues and determination of suit.
Or global,
I cannot recall.
all issues of law,
On issues.
all issues agreed upon.
Yes, sir. All
This
issues.
is the issue of law
Yes.
about which Sanjay has asked. Yes, you.
If the non-resident Indian wants to recover the possession of his property, what are the provisions as per East Punjab Urban Rent Restriction Act?
So if a non-resident Indian is trying to seek the property, firstly he must have been owner of the property for 5 years. Only after that he gets a remedy under East Punjab Urban Rent
You are
Restriction
right.
Act.
You are right, Harjinder. Suppose today NRI has come. He has reached today in a deal. He wants to get his property evicted. Then, under which law he will move an application?
So property was rented.
Yes, he has given the property on rent. He wants to get it evicted from the tenant.
Urban Rent UP East Punjab Urban Rent Restriction Act,
East Punjab.
Section 13 Clause A or 13 capital A.
No, Harjinder, it has been now, that act has been repealed with regard to NRI. NRI can move application only and only
Yes,
under
sir.
Punjab Rent Act 1995. He cannot go to
Yes.
that act because for him earlier act has been repealed.
Yes, sir.
So, if the police officer has refused to register the FIR, whether the aggrieved person can directly approach to High Court for registering of FIR?
There, Honorable High Court has already mentioned that accused need not come to the Honorable High Court directly by itself, because the section itself provides the accused can firstly move to the Commissioner of Police or Senior Superintendent of Police.
Mhm.
Then he has other remedies available as to move to the court by giving a complaint or seeking the court to make an order under 156 clause 3 to direct the police officer to start investigation. And if the court makes an order under 156 clause 3, the police officer is bound to firstly file an FIR and then proceed with investigation. So the Honorable High Court has already said, if those remedies are relinquished, then you come to us.
Yes, Sanjay, can you say something more on
So there was a landmark judgment also on this particular matter. It was Sakiri Vasu versus State of UP. And in that, Supreme Court has specifically laid down that the final process to approach the High Court is the last resort. When all the ultimate channels have been exhausted, only then you can approach the High Court. And it is having power under 498 of CRPC to register that particular FIR in case the earlier stages or earlier channels have been exhausted.
All right, Sahib.
So in a case, there's an FIR that has been filed and the police has investigated and completed their investigation. They have presented a cancellation report in front of the Ilaka magistrate. Now, can the judicial magistrate ask the police to, instead of giving a cancellation report, to file a challan instead of it? This
On
has
the basis
been...
of the facts. The magistrate is of the opinion that there is something solid substance you should present a police report.
I cannot tell it properly, but what I can recall is magistrate is not bound by the police report. So magistrate can even take cognizance of charge other than those mentioned in the police report and cannot take cognizance at all. Implying from that, I can say that magistrate is also not bound by the closure report, by the police officer, cancellation report, and still can take cognizance.
So his question is whether he can give direction to the police officer that you should send a police report, and there is a specific case, which case is against the accused.
No, sir, it is not the domain of the magistrate.
Exactly, it is the domain of only of the police
Investigation,
department to
yes.
investigate. And the judicial magistrate, he cannot give direction to them as to how the investigation is to be conducted.
Yes.
Because he is having his own power, he can take cognizance, he can discharge the accused, he is having all powers. Is you.
What are friendly suits?
Friendly suits are special cases mentioned under Order 36 of the CPC, and they are mentioned as special cases. Right? So there the parties come together by an agreement to the court and they frame their own questions of law upon which they want to settle their dispute, and the court take cognizance. After taking cognizance, it will require, all the issues have already been framed, so court will take evidences from both the parties and pronounce a judgment thereon.
Can you say something about bail granted by the judicial magistrate when the police report is not coming within specific period?
Sure. It is default bail provided itself under section 167. 167 clause 1 sub clause B.
Sometime you may not know the clause.
Yes.
Simply section will suffice.
Yes. So in that, if the case is where imprisonment is minimum 10 years, in that case the time period is 90 days in which challan has not come, and otherwise for 60 days if challan has not come and accused was in custody, then he can be released on bail. And it is the right of the accused.
For example, there is a imprisonment of 14 years in an offence. Then what consider that it is section 393 or 392 where 14-year imprisonment can be given. Or in that case, what period you will calculate, whether it will be 60 days or 90 days?
60 days, sir.
60 days. Why 60 days?
Because the section says in crux minimum 10 years. Where the
Minimum
imprisonment
word
is
has been used or some other word has been used?
some other word has been used. I was implying it
Not
from
less
so
than.
the exact word is
less than 10 years.
not less than 10 years. Yes.
Not less than 10. Yes, sir.
Can you throw some light on section 151 of CPC?
So 151 provides inherent powers to all the courts, all the civil courts in CPC dealing with civil matter. So inherent powers of the court are provided to all subordinate courts also. But if we compare it with the criminal procedure, the inherent powers lies only with the Honorable High Court, because in civil case the matter is where we have to try the suit and give a judgment based upon balance of convenience only. So, and there is no fundamental rights of the person being abridged, where the person will be sent to the custody or to the jail. So we can use our inherent powers to go beyond the matters and give extra remedy in the civil procedure itself. It is flexible procedure.
Alright. So I have one question.
So, according to Limitation Act, okay, laying emphasis on limitation, let's say there is a suit for a property which is being filed by the child of a person after the duration of 12 years for an immovable property. Okay, and he is only filing it after 12 years because he was under special incapacity of not filing a suit, being underage, being a minor. Okay, now let's say that after filing the suit or during the filing of suit, he still has a certain period. Let's say he has 5 years of limitation still left from the original period and he has filed the suit. But there is a certain section in Limitation Act which says that only a period of 3 years will be allowed.
Yes, sir.
So can you tell us which period will be given to him? Whether he'll be provided the 5 years or whether he'll be provided the 3 years?
Have you understood the question?
Yes, sir.
The period of limitation is still 7 years are left.
Yes, sir.
But section 8 says that the civil suit must be filed within the period of 3 years after obtaining majority. Now whether we are to give 3 years or he can avail 7 years also.
He has to file suit within 3 years, but what section 27 talks about is he will be given period of 3 years only, but
Only
as
3
period
years
of
because
limitation.
after a
But adverse possession will not take place till 12 years.
We are not concerned with the reverse possession. We are concerned with only limitation of filing the suit.
Sure, sir.
Reverse possession is a different concept.
So in my view, 3 years only.
No, he should be given 3 years. So he will say, when Limitation Act gives him 12 years, why you are putting restrictions on his right? When Limitation Act says that it will be 12 years. Suppose period of 12 years have elapsed.
Yes, sir.
Then of course we can say that now civil suit can be filed by him within the period of 3 years from the date of majority.
Okay, sir.
But we cannot put any restriction on his rights
Yes, sir.
given by the Limitation Act. Can we?
No, sir. Happy. Yes, sir.
We cannot. So you are referring to the adverse possession.
Yes.
What is the adverse possession? Can you make some reference? Can you explain that? What is this concept?
So, adverse possession is a concept in civil law where we are dealing with immovable property. You have a right to get possession back in 12 years, in the limitation period. And if
Can you refer to the section also? Which is the section?
27 of the
27.
Act. So, if you are not seeking possession of your property and the possession of the other party was uninterrupted and it was open and there are certain other conditions, then the person in whose possession the property was for that period of time, it becomes indefeasible. So, when it becomes indefeasible, the party cannot challenge it.
Can he use this adverse possession as a shield or as a sword? Have you heard both the words?
Yes, sir. So, shield is defense and sword is he is filing a suit as a plaintiff himself.
He can use it as a shield or as a sword.
He can use it as shield and sword both.
Both.
Yes, sir.
Can you make a reference to some law where it has been provided that he can take both the aspects?
It was a judgment named Ravinder Kaur versus
I
Gurdwara.
remember that part, very, very important.
Sure.
After that, some authorities, more authorities have come. Recently.
How will you compare penultimate act with last proximate act under section 511 of IPC?
Sure, sir. Proximate act is, if we talk about stages of crime, the proximate act is when we have surpassed the attempt. Like the process of committing crime was initiated and the commission is so proximate. the stage is so proximate to the commission, it is
Can you give
inevitable.
some example?
So
Any example?
yes, so a person comes with a bullet, a gun loaded with a bullet. He pulls the trigger and arms it at the person. Now, when he fires the bullet, the act is so proximate, attempt has occurred. If the person whom he was shooting at, he dodges the bullet. Now, even if it was not murder, it was attempt to murder.
Whether attempt to murder will come under section 511.
No, sir, it is separately mentioned.
Give some
So my
suitable-
example was wrong in this
give
case.
some suitable ones.
Suitable example.
Alright, go through that cr.pc and find out some suitable.
Sure, sir.
Yes, you have one question.
A person is already dead. Is it possible that any of the statements by such a deceased be used in evidence?
Sure. So, firstly, the statement by the person who is already dead, it can be used under section 32, where it provides if the person cannot be called to court, and it includes the person cannot come owing to his death or other circumstances. So, it can be used for several purposes provided under 32, and the main of them is 32 clause 1, which is dying declaration if it was in relation to his cause of death. Secondly, it can be used under section 33, where he already gave a statement in the same suit, and in the subsequent part of the proceeding, we need to use that statement itself. Then we can use the same statement. Other than that, if his
33, what is the difference between the statements in the section 33 and 32?
so in
Because
32,
under section 32,
yes, sir.
there is no need that he might have been cross-examined.
Yes, sir.
But under 33,
Opportunity must be given.
cross-examination, the opportunity must be given to the opposite party.
Sure, sir.
Yes, sir. Please.
Can you explain the maxim de Bennett essay examination?
No, I have not heard about it.
Suppose if somebody wants to go to court regarding, and the case is still for the purpose of filing judiciary, he wants that his statement should be recorded because he is leaving the country. Now, his statement can be recorded without bringing the charge, without bringing the issues.
Sure.
Under specific provisions of law. Yes, which provision? Order 60,
18 to 16.
orders
18 to 16.
Rule 60. Go through that. This question was asked by like at some point.
Okay.
Yes, sir.
So, under section 114 of Evidence Act, it says that court may presume certain facts. So, under that section, can a court also presume that two people are married who have not, there is no ceremony that has taken place?
For long prohibition.
Yes, sir. So, other than 114, I can say court must presume in favor of marriage. But 114 is used for creating an adverse inference.
It is not relating to that. It is not relating to that fact which he has narrated. So, or it can help. The case can fall under this section 114 if two persons they have been cohabiting for a long period, and whether under section 114 court may presume that they are husband and wife. Under section 114.
Court can presume so,
Under 114.
not under 114.
Exactly, under 114. See that also, there is a specific example also under 114. Alright, Harjinder, you have given good replies, but be quick.
Sure, sir.
Make the principal go through that law, have command over law. Your answer must be ready because you have gone through all the entire law. Alright, Harjinder, thank you.
Thank you.